evening, everyone. Thank you for spending your evening with us. My name is Kirsty Robson, and I'm one of the co-executive directors of Yet Again, a youth-led initiative that encourages young people to discuss and do what they can to prevent modern atrocity. We're delighted you chose to join us for our webinar this evening, hosted by my wonderful colleague and fellow co-executive director, Jill Collins. The Genocide Convention signified an international commitment to preventing genocide and protecting human groups. Yet time and time again, genocide has happened since the Holocaust. We're seeing information about the persecution of the Uyghurs in the news today. And if anything, now is the time we have to act. In this webinar, Joe is going to explore how the convention defines genocide.
Yeah.
How the Genocide Convention defines genocide and illustrates how the convention is ill-equipped and unprepared to deal with the reality of modern atrocity. And with that, I'm delighted to pass back over to Joe.
So, hello and welcome everyone. First of all, again, I'd like to reiterate, thank you so much for coming. This session is recorded. So if you know anyone that either wants to come along or you think will be interested afterwards, you can send this over to them once it's uploaded to our YouTube. Now, the topic of tonight's session really comes down to the Genocide Convention, and although I'll be talking about international law, international criminal law, don't worry, you don't have to have studied it. Law doesn't have to be your background. This session is designed for everyone. It's accessible to everyone. So that's just a short disclaimer at the beginning. Now, the topic of tonight's session really comes down to the effectiveness of the Genocide Convention in protecting human groups. What I'll do is I've got a presentation and I'll start sharing my screen now. There we go. So as Kirsty said, since the world promised that the horrors of the Holocaust would never again be repeated, we've seen genocide in Bosnia, Rwanda, Cambodia, Darfur, Myanmar, and as Kirsty mentioned, at the time of this session, against the Uyghurs in East Turkestan. Parties to the Genocide Convention have a duty to prevent and punish genocide where they learn of a serious risk that genocide will be committed. It therefore begs the question, why does genocide occur yet again? Now, as many of you will be aware, there isn't a straightforward or simple answer to this question. But what I'll be focusing on tonight is the ability of the Genocide Convention to effectively prevent and punish genocide. And in doing that, I'll be focusing on one very particular but pivotal aspect of the convention, which is known as specific intent. But more on that as we come to it. Now, before we go on to look at the convention itself and international law, we must first ask ourselves, what is genocide? Now, before I answer this question, I'd be intrigued just to see what you would say. So if I was to ask you, what is genocide? What would your response be? If you could put your answers in the chat box, that would be really helpful. I'll just stop sharing because I realise I can't see the chat box otherwise. I'll just give that about 30 seconds. No, not to worry. If anyone does message, just shout. Oh, right, so we've got the eradication of an entire entity. Yeah. Deliberately killing large numbers of people. Okay. Right. Any more for any more? Yeah. Okay. So I'm really glad, particularly with those two answers. So the eradication of an entire entity and deliberately killing large numbers of people. Now, I want you to hold those thoughts, particularly, Amelia, on the deliberately killing large numbers of people point, because it's something that I'm going to focus on quite a bit when we look at what is genocide. Now, genocide, share my screen again. Now, genocide may, when we think about it, it seems to be something that has existed time immemorial. We can think of genocide occurring across the world throughout history. But it is a concept, and it is a relatively recent concept that was developed in 1944 by the gentleman I've put on the screen, Raphael Lemkin. Now, Lemkin was a Jewish-Polish legal scholar, and he conceived the crime of genocide in his book, Axis Rule in Occupied Europe. I've put the book on the screen, so if anyone would like to take a picture, go away and read Lemkin's work, I would recommend doing so, particularly chapter 9, which is the chapter dedicated to this concept and this conception of genocide. Now, Lemkin coined the term genocide as an amalgamation of the ancient Greek genos, meaning race or tribe, and the Latin side, meaning to kill. So quite literally tribe killing, group killing. Now, Lemkin's conception was an active response to the atrocities committed by the Nazis and their collaborators during the Holocaust. The failure of international legal provisions, as Lemkin saw it, did not adequately capture the atrocities that were being inflicted upon the Jewish people during the Holocaust. And this, Lemkin wrote, and I'll quote, he said, "a new term to reflect a new conception." Now, as I've already mentioned, chapter 9 was dedicated to this new concept of genocide. And throughout this chapter, he explores in detail what genocide is. But at the very beginning, Lemkin defines genocide as this, and I've put the highlighted section on the screen: a coordinated plan of different actions aiming at the destruction of essential foundations of the life of national groups, with the aim of annihilating the group themselves. The objectives of such a plan would be disintegration of the political and social institutions of culture, language, national feelings, religion, and the economic existence of national groups, and the destruction of the personal security, liberty, health, dignity, and even the lives of the individuals belonging to such groups. Genocide is directed against the national group as an entity, and the actions involved are directed against individuals, not in their individual capacity, but as members of the national group. Now, that is quite a long definition, but I find it helpful to consider it in two parts, having two key foundational elements to the definition of this concept of genocide. The first is that the victim of genocide isn't the individual per se, but it is the human group as an entity itself. So the prevention of genocide recognises the sanctity of human groups. And that's why I was very keen to have your thoughts. I think Tammy mentioned, the eradication of a group as an entity, and that's key. The second part is the underscoring of how destruction can occur through both physical, non-physical means, really the foundations of that group. Now, it mentions the lives of individuals being just one of those essential foundations. It also looks at non-physical techniques, so culture, language, religion, and so forth. Now, although Axis rule in occupied Europe was an active response to the Holocaust, Lemkin had been working on proposals to protect human groups in international law before the Holocaust. And this he took inspiration from the persecution of the Armenians by the Ottoman Empire. Now, in 1933, Lemkin submitted proposals at an international conference in Madrid for two crimes, and I've put both of them on the screen. The first crime is barbarity, and the second, vandalism. Barbarity, Lemkin defined as the oppressive and destructive actions directed against individuals as members of a national, religious, or racial group. So oppressive and destructive actions. Vandalism, he defined as the malicious destruction of works of art and culture because they represent the creations of the genius of the group. So you've got these destructive actions more in a more physical sense, but also this cultural sense of destruction as well. Now, the reason I've drawn attention to both of these crimes, even though they were proposed in 1933 and didn't take off, no action was taken following this, is that because Lemkin says both of these crimes amount to genocide. So taken together, they amount to genocide. Now, as I previously mentioned, in conceiving genocide, Lemkin put a strong emphasis on the sanctity of human groups. And Lemkin was really quite critical of international law as it then stood. So on the screen, I've put an example of just sort of the problem Lemkin was alluding to, and this is Article 46 of the 1907 Hague Regulations. Now, Article 46 provided that belligerents must respect family honour and rights, the lives of persons and private property, as well as religious convictions and practice when occupying the territory of another state during times of military conflict. Now, those, of course, at the time were seen as key humanitarian provisions, you know, the protection of religious conviction and practice, minority rights in times of occupation. But that protection only existed in times of occupation during military conflict. The same protection was not offered in times of peace to groups within the boundaries of their own state. And this was Lemkin's principal criticism of international law. It only deals with the sovereignty of states, but, and this is a quote from Lemkin, but is silent regarding the preservation of the integrity of a people, end quote. So the sanctity of human groups was something international law at the time simply did not address. And this is what Lemkin was key to address in conceiving the crime of genocide. So Lemkin saw human groups as an essential foundation of the world's community, and in their destruction, the world loses future contributions from that group, and thus Lemkin wrote, such destruction offends our feelings of morality and justice. So in understanding what makes genocide distinctive, in answering that question, what is genocide? I think Lemkin is clear. It is the destruction and subsequent loss of a human group. Now, there is, of course, as you can imagine, significant scholarly debate as to what the human group is and how to interpret Lemkin. So Anthony Dirk Moses, who's a fantastic academic in this field, categorises the different interpretations into two schools of thinking, the liberal and the post-liberal. Now, don't focus too much on the terminology, just suffice to say that there are two principal categories of thinking on interpreting genocide. So the liberal interpretation sees human groups as a collective of individuals, and as such, they can only be destroyed, as it were, through physical extermination. So for example, if you just see the group as a collection of individuals, you can only physically kill those individuals to destroy the group. The post-liberal interpretation, which I should add is my interpretation, is that human groups are a composite of cultural structures and individuals which can be destroyed through both physical and non-physical techniques. So for example, if you had a Muslim group, the prohibition of religion, although immediately you know you're not physically killing those individuals, in prohibiting that religion is no longer taught, and eventually the Muslim faith, that is the heart of that group, ceases to exist as future generations ensue. So the destruction of groups, in my view, is not conditional on merely physical extermination of individuals, but it can be something much more abstract and much more non-physical, such as, for example, the prohibition of religion. Now, the reason this is my view is because I would argue that the post-liberal interpretation is the most reflective of Lemkin's work. So Lemkin wrote, and I'll quote, "The world represents only so much culture and intellectual vigour as are created by its component national groups," end quote. So Lemkin himself is recognising that the destruction of human groups result in the loss of something more. And this was, you know, if we think back, this was made clear with the crime of vandalism. Now, the two interpretations become vital when understanding the techniques of genocide. And this is why I asked the question to start with, how is genocide perpetrated? Now, the liberal interpretations I've already briefly touched on excludes non-physical or cultural techniques of destruction. It emphasises solely on the physical destruction of individuals. This would be, for example, you know, mass killing, endangering health or biological techniques, such as reducing the birth rate of a group, or through sterilisation or the separation of males and females, all these techniques that would have a physical impact on the group. Now, these are, of course, all possible and legitimate, and if we look through history, utilised techniques of genocide. However, Lemkin expressly included, economic, religious, cultural destruction as well in that original definition. Indeed, part of Lemkin's thinking took inspiration from the effect of colonisation and the slow eradication of human groups. So ultimately, and this is the part I ask you to take note on, is Lemkin emphasised destruction as a consequence. Now, the liberal interpretation doesn't do this. Liberal theorist's attention is drawn to how a group is destroyed. That is to say, it looks at the technique rather than the effect. So the intention of the perpetrator in carrying out this technique becomes the focus. So you're not asking, has the group been destroyed? You're focusing on how the group was destroyed. Now, that is, I understand it may be very quick, and if you do have any questions, I will be taking questions at the end, so do note those down. But the reason it's important to look at the different interpretations of genocide is because ultimately one of those interpretations will be reflected in law and therefore in the Genocide Convention. Now, as I've just explored, Lemkin's conception of genocide is the destruction of human groups through both physical and non-physical techniques. In short, it involves looking at the consequence of destruction rather than the purpose of destruction. Now, this was not the view of the drafting parties to the Genocide Convention. Now, in 1946, Lemkin's international campaigning led to the General Assembly of the UN passing Resolution 96-1, requesting the Economic and Social Council of the UN to prepare a draft convention on the crime of genocide. In this resolution, genocide was defined as, and I'll quote, the denial of the right of existence of entire human groups, as homicide is the denial of the right to live of individual human beings. Such denial of the right of existence shocks the conscience of mankind, results in great losses to humanity in the form of cultural and other contributions represented by these groups. Now, although this definition reflects it in a broad term, Lemkin's conception of genocide, the right of existence of entire human groups, it's already showing this predisposition to physical destruction. So there is a link to an initial reference to homicide, this idea of physical killing. And although there is an observation of the cultural loss that genocide incurs, that it's merely an observation of the loss that would ensue from physical destruction, not to say that the group can be destroyed through cultural means per se. Now, debates in draft texts were dominated by this liberal interpretation, and the Secretariat draft is the one I put on the slide, was the first draft prepared by, as you can see, the ECOSOC. I put that at the bottom of the screen. Now, there was very little appetite to entertain non-physical or cultural techniques of destruction. Emphasis was placed solely on physical techniques. Now, the Secretariat draft was compiled by the UN Secretariat, and it was composed with the assistance of 3 leading international scholars. These were Henry Donadieu de Vabre, Vespasian Pella, and Raphael Lemkin. So Lemkin was, key in these drafts. Now, Lemkin argued, and this is a section I've taken from that report, that draft. Lemkin argued that the techniques of genocide should be categorized into 3: physical, biological, and cultural. Now, the other 2 scholars disagreed. They agreed with categorizing both physical and biological techniques. However, they did not agree with the third, and you can see sort of rhetorically at the outset of the report, should all these 3 notions be accepted or only the first and second? That is the second general question to be decided. So Lemkin from the off was the only scholar prepared to recognise that genocide contains these three categories of destruction. Now, as we go on into the report, we can see that both Donadieu, de Vabra and Peller considered cultural genocide to be an undue extension of the notion of genocide. And from the outset, genocide was being restrictively interpreted in comparison to Lemkin's original conception. Now, in doing this, it shows that the drafters of the convention were less concerned with the outcome of destruction, the idea of that consequence of destruction, but instead focused on the perpetrator and their actions. And this again can be seen throughout the report. So when, for example, they were discussing acts of violence committed by individuals or communities, the draft notes that these would be outside the notion of genocide, where the intention to physically destroy a human group is absent. Equally, when discussing conditions that result in the debilitation or death of individuals, the draft describes this as a slow death, where the intention of the author of genocide may be less clear. Intention of the perpetrator is gaining, as we can see very early on, significant attention throughout draft texts. Now, yes, and that was just a key point I wanted to draw attention to, is the idea that genocide, this is something that was also referenced in the notion of genocide at the outset of the report, is that genocide is the deliberate destruction of a human group. And that's something I'd ask you to take note of, particularly when we come and look to the eventual definition. The Genocide Convention defined genocide. It's easy to categorize it into two parts. First, you must commit one of the, as it were, genocidal acts, the physical acts outlines at subpoints A to E. So, for example, killing members of the group, causing seriously bodily or mental harm to members of the group, and so forth. You must commit these acts with what is known as specific intent. And this is really at the heart of tonight's session. So you must commit one of those 5 acts with an intention to destroy, in whole or in part, a national, ethnical, racial, or religious group as such. So it's insufficient that the perpetrator intended to undertake that criminal act. So, for example, the perpetrator intended to kill members of the group. They must kill members of the group with the intention to destroy, in whole or in part, that group as such. The perpetrator, in essence, must will that consequence. Knowledge, again, is not sufficient. Now, intent is exceptionally difficult to prove. Only the perpetrator has knowledge of their intent. So, in practical terms, intent must be inferred, and specific intent under the convention is precise and therefore creates an exceptionally high threshold in proof. And this is something I'll come on to look at in a bit more detail. So, for example, if you are going to infer intent, you will have to look at the actions of the perpetrator. So, the inevitable consequence is that widespread, planned, or systematic genocides are more likely to provide such an inference, whereas smaller scale, non-systematic, non-planned genocides will go unrecognised. And this was regrettably the case in Darfur. So the commission for Darfur, there was a commission that investigated whether or not the Sudanese government were committing genocide in Darfur, and the commission concluded that the government of Sudan had not pursued a policy of genocide. They were satisfied that genocidal acts had been committed, but that the specific intent could not be made out as far as the central government authorities were concerned. And that's that second highlighted section there. Now, this is one of the most fundamental failings of the Genocide Convention. It is so restrictively drafted that it inhibits instances of genocide, of group destruction, being recognised as genocide. It means that perpetrators will not be held responsible for genocide, and that the obligation to prevent and punish genocide does not arise. Now, rather than just looking at it in a rather abstract sense, I think it's really helpful to get into the detail. And for tonight's session, I've actually picked two key cases before the International Criminal Tribunal for the former Yugoslavia. Now, between the convention being ratified, it wasn't really applied until the 1990s with the ad hoc tribunals for Rwanda and Bosnia. Now, the two men I propose to look at are both Bosnian Serb leaders, Momcilo Krajnik and Radovan Karadzic. Now, Krajnik was acquitted of genocide before the ICTY because they couldn't establish specific intent and therefore genocide. Karadzic, on the other hand, was convicted on one count of genocide but acquitted on another. And the reason I've highlighted his case, and we're going to look at it, is because when you actually look at the reasoning between the acquittal and the conviction, you start to see the failings of specific intent and of the convention. But turning first to Momcilo Krajnik. Krajnik was president of the Bosnian Serb Assembly, and he was an active member of the presidency of the Serbian Republic. Now, he was charged with and found guilty on 6 counts of crimes against humanity and war crimes. Now, Krajnik, like most senior leaders, didn't physically commit these crimes. He didn't physically kill any members of the Bosnian Muslim or Bosnian Croat groups. But the approach the ICTY took, which is exceptionally interesting, was one of joint criminal enterprise. So they looked at these crimes as part of a wider criminal enterprise, and liability was apportioned based on that individual's participation in that joint criminal enterprise. Now, Krajnik was found not guilty on the counts of genocide on the basis that the objective of this joint criminal enterprise did not amount to an intention to destroy the Bosnian Muslim or Bosnian Croat groups as such. And this was despite there being a finding that genocidal acts had been committed and guilty verdicts being returned on the crimes against humanity counts. Now, the reason the Krajnik judgment is exceptionally problematic is because it features what some academics refer to as genocidal double rhetoric. And this is the idea that perpetrators are able to avoid liability by framing their genocidal acts in a certain way. Now, I've highlighted a relevant section from the judgment itself. On the 12th of May 1992, following a speech by Radovan Karadzic in the Bosnian Serb Assembly, where he outlined the strategic goals of the Serb people, General Ratko Mladic expressed practical concern over plans to ethnically cleanse municipalities across Bosnia-Herzegovina. Now, Mladic said that he did not know how Karadzic would explain this to the world. This would be genocide. And he went on to say, and this is the section I've highlighted from the judgment, we should not say we will destroy Sarajevo. We need Sarajevo. We are not going to say that we are going to destroy the power supply pylons or turn off the water supply. No, because that will get America out of its seat. But one day there is no water at all in Sarajevo. What it is, we do not know. And the same with the electrical power. We have to wisely tell the world it was they who were shooting, hit the transmission line, and the power went off. They were shooting at the power supply facilities. That is what diplomacy is. Now, although the ICTY cite this speech in the judgment, and that's what I've highlighted on the slide, the ICTY did so to say that Mladic was proposing an alternative to genocide. So not only are perpetrators able to quite clearly mislead international diplomats, as Mladic was making clear, but also judges before the ICTY. And this is the most troubling part about this. It gives perpetrators control over whether a genocide they are perpetrating is recognised as genocide. And that is because, primarily, this fixation on the specific intent of the perpetrator, the purpose of the actions the perpetrator is undertaking. Turning now to Karadzic. Now, Karadzic was president of the Serbian Republic and supreme commander of the armed forces. So he was one of the highest in command and one of the most liable perpetrators and leading figures in the Republic. Now, Karadzic was charged on 11 counts. He was convicted on 5 counts of crimes against humanity and on 4 counts of war crimes. The charges of genocide were separated into 2 counts. Count 1 referred to the genocide committed throughout the municipalities, and count 2 to the genocide in Srebrenica. Now, the ICTY found Karadzic guilty on count 2, namely for the genocide in Srebrenica. However, they found him not guilty on count 1 in the genocide committed throughout the municipalities because they couldn't establish specific intent. Now, on the first count, the trial chamber was satisfied that the actus reus, these genocidal acts, had been committed, namely mass killing and causing serious bodily or mental harm had been established. But, similar to Krasnik, they found the objective of the overarching joint enterprise to not have the requisite genocidal intent. They found, and this is a section I've quoted, the objective was to create an ethnically homogenous Serb state in Bosnia-Herzegovina, and that this was distinct from an intention to physically destroy those groups as such. So the tribunal made clear that there is a distinction in terms of intent between to ethnically cleanse an area and to destroy that group as such. And as such, Karadzic is not liable for the genocide committed. Now, even to date, there is no finding in a court that genocide was committed throughout these municipalities. But what did the court find in these municipalities? And this is where this judgment becomes exceptionally concerning. One of Karadzic's convictions was for extermination as a crime against humanity. Now, extermination in law is substantially similar to genocide in that it has the self-same consequence, the destruction of the group. Extermination in law is the annihilation of a mass of people. And to be convicted of this, the perpetrator needs to have knowledge that his actions are part of a vast murderous enterprise in which a large number of individuals are systematically marked for killing. Notice the difference: knowledge instead of specific intent. Now, in convicting Karadzic of extermination as a crime against humanity throughout the municipalities, the ICTY is confirming that the Bosnian Muslim and Bosnian Croat groups had been subject to a widespread and systematic attack of mass killings, which it will be prudent to conclude destroyed these groups in part. And if we think back to Lemkin's original conception of genocide, this is undeniably genocide. But under the convention, this is not recognised as such, and the stumbling block is again specific intent. Turning now to the second count where Karadzic was found guilty. So in the same way as the municipalities, the ICTY found that genocidal acts had been committed in Srebrenica. They also found that genocidal intent could be established. Why? Because the genocidal acts were carried out pursuant to a systematic and highly organised plan. The trial chamber identified in the same way as the overarching joint criminal enterprise sought to ethnically cleanse Bosnia-Herzegovina, the Srebrenica joint criminal enterprise initially shared the same objective. So they initially intended to ethnically cleanse the area, but that this transformed into a concrete common plan to eliminate the Bosnian Muslim population. And in reaching that conclusion, particular reliance was placed on a phone conversation between Karadzic, where he spoke in code of the plan. The ICTY used this as evidence. I think when I look back to it now, it was about moving the cargo, speaking in code about this operation, this genocide. And this, the ICTY concluded, was evidence of a malign intent, a common plan to destroy the Bosnian Muslim population. Now, even though Karadzic was found guilty of genocide and the ICT recognised what happened in Srebrenica was a genocide, how this finding came to be is again deeply problematic and really highlights the inadequacy of the convention. The only reason Karadzic was guilty was because the genocidal acts were systematic and organised, and it was part of a plan. Neither of these facts should have any bearing on whether or not we recognise that something like that as genocide, let alone them being deciding factors. The application of the convention before the courts quite clearly shows whether or not a human group is destroyed isn't the focus of the Genocide Convention or indeed international law. In short, the convention focuses far too heavily on the purpose of destruction as opposed to the fact of destruction. Now, I notice I'm going through this, there's a lot to try and take in here, but I would like to quickly look at reform. What can be done to rectify this? And at the moment, we look very much at a purpose-based approach. We look at the purpose of the perpetrator in undertaking those genocidal acts. The reform I would suggest, and other academics in this field, have really advocated for, is what's considered a knowledge-based approach. So currently, specific intent is purpose-based, looks at the purpose. That is where the focus is when it comes to intent. It requires not just knowledge, but also will. The perpetrator must will the consequence of those actions. Now, I believe that if you take away that element of will from the convention and solely rely on knowledge, you would have far greater success of not only recognising genocide, but also being compliant with general criminal law principles. Crimes against humanity, which I've put on the screen, already has this as its mens rea mental element. So to be convicted for crimes against humanity, you must be part of a widespread or systematic attack against any civilian population, and the acts are there, but you must do so with knowledge of the attack, not specific intent, knowledge. So the introduction of a knowledge-based approach wouldn't be novel in international law, and it's something that is already being applied to other international crimes. Now, I will recognise that there is a risk that a knowledge-based approach would encourage what I would consider willful blindness. And they will make efforts to conceal their knowledge of operations. That is something that would naturally, I think, prevail if this was to be the case. But that is something that can and should be avoided. Now, there's a fantastic academical stress, and I've put his article on the screen if anyone would like to go away and read that, which I would recommend. And he really proposes, really insightful reform for a knowledge-based approach. And he includes knowledge of a real risk caused by a genocidal act. And that would be key. So this would be a relatively low threshold, and it will be more likely to include what we could consider reckless genocide. But genocides that are committed in the absence of any organisation or plan. And what this would do ultimately is refocus international law at looking at the consequence of destruction. Has the group been destroyed, as opposed to why the group has been destroyed? For me, that is one of the key aspects any form of reform should take. We must prioritise the experience of victim groups when genocide is committed. And until we do that, we will not adequately be protecting them. Now, I'd like to leave things there and open it up to questions. I recognise there may be a lot to digest in that, but hopefully we can have a bit of a discussion now. Oh, there we go. So if anyone does have any questions, you can either pop it in the chat box or unmute yourself and ask that question.
I have a question if we want to kick things off. Sorry, I'll put my camera on. That was a really interesting talk. Thanks for that. I was interested, particularly on groups, this idea of how groups are characterized when it comes to when genocide is prosecuted. And there's a particular focus on how groups are identified, as you were saying, sort of very objectively. There are very specific types of groups that are can be considered for it to be a genocide. I was wondering what your thoughts were on perhaps a shift to a more subjective understanding of groups, where instead of how these particular identities, but more of a shift towards how the perpetrators identify and consider the victims, because at least from my point of view, I've always thought that's a slightly better way of doing it, because they are the ones who are committing the genocide, and therefore their interpretation of the group might be better. So I was wondering what your opinion might be on that, as opposed to these more rigid ones which we currently have.
Yeah, it is. I'm glad you've raised that, because it is exceptionally, I think, one of the hardest questions to answer, especially when it comes to reform. So at the moment, the protected groups are national, racial, ethnical or religious. You have to be one of those four groups, gender, sexuality, any other group, whether it be political. If there is in any way a destruction at the moment, that is not recognised as genocide. And I think rightly there has been a lot of discussion and commentary and concern about it just being those four groups and actually being quite restrictive. I think there is, as you said, there is proposals for a more subjective basis, on how you identify those groups. Do you identify them perhaps as the perpetrators see them, or self-identification? I would say that when you look at perpetration from the perpetrator's perspective, and you're looking at it solely as a purpose of establishing mens rea as a mental element, it would make sense to recognise that that is how you identify the group. I am, however, cautious about that approach, and I think self-identification is often useful, because often when if we view the group objectively, if we don't look at the group of the way the group itself identifies, we are failing fundamentally in international law to recognise the sanctity of that human group. And I think the trap you would have in recognising from the perpetrator's perspective is that you would be endorsing in international law often racial theories. So, for example, if the Holocaust at Nuremberg, there was this charge of genocide, which of course came after Nuremberg. At the time it was crimes against humanity. When you look at how do we define the victim group, would we have gone through the definitive process of identifying the victims of the Holocaust as the way the Nazis identified Jews, for example? I think you run the risk then of actually embedding in international law very, very offensive and sort of racially motivated stereotypes and views. And it's something that I would caution against. But it's a really great question, and I don't think there's any easy answer to this idea of groups.
Joe, we've had a question sent in advance. I wonder if you'd give your thoughts to it.
Yeah.
If you could change the way the international community responds to genocide once we know it's being committed, what would be the first thing you would do?
Okay, so this is by no means an easy question. The one thing that I have always said is the most effective is state collaboration. At the moment, the obligation to prevent and punish genocide is one on individual states, but to have effect, you have to have international cooperation. You can't have one state, as it were, taking on a genocidal state, because the difficulty you have is that state would have to justify politically either the sacrifice of its own armed forces personnel and an exceptional amount of money, and a single state frankly would not do that. So the first thing I would do as a response is ensure international collaboration to recognise genocide. I think is the first step. You need to recognise that this is in fact genocide. And I know that may seem, to have little effect? Well, at the moment, that simply doesn't happen. If we look at what's happening with the Uyghurs in East Turkestan, very few countries at the moment are prepared to recognise that that is in fact genocide, or have a mechanism whereby that determination can be made. And as such, states just avoid those obligations under the Genocide Convention. So I think as a very first basic fundamental step is genocide determination on each individual states, and then international collaboration on actions. You know, I think the key point of the Genocide Convention, you know, that principle of never again, was this idea that states cannot do to their own people, they cannot commit genocide to their own people, and they cannot do so with impunity. States cannot have the same relationship with criminal states as they would under any other circumstances. So, for example, you cannot trade on preferential terms with a genocidal state. To do so would allow that state to perpetrate its genocide with impunity, as an example. And that is something I believe internationally states can look at. They can look at that relationship internationally and come up with a common plan. I hope that helps.
Hi, Joe. Just wanted to say that was...
Also, go on, Amelia.
Sorry, that was really informative. Thank you so much. I recognise it's probably a bit of a difficult question, but I was just kind of wondering what are your thoughts on how the Genocide Convention might kind of prevent or hinder the successful indictment of any members of the CCP that are currently contributing to the persecution of the Uyghur Muslims?
Yeah, it's a really good question for a number of reasons. So what's happening against the Uyghurs in China at the moment is met by a significant stumbling block in the application of the convention. So ordinarily, you would expect the convention to be applied at either the International Criminal Court or the International Court of Justice, primarily the International Criminal Court, because they are a criminal court rather than a civil. China does not have the ability to be investigated by the ICC. You know, for the ICC to have jurisdiction over a case, either where the genocide is perpetrated, that state must be a signatory to the Rome Statute, which is the ICC statute, or the UN Security Council must make a referral to the ICC. Now, China isn't a party to the Rome Statute, and it's on the UN Security Council, so would veto any form of referral. So the ICC is out. Frankly, it does not have jurisdiction. It can't hear the case. The same can be said for the International Court of Justice. The International Court of Justice, in a contentious case, those state parties must consent to the ICJ's jurisdiction. The ICJ, quite simply, would not have jurisdiction because China would not consent. So the two instrumental international courts we have to apply the convention are not appropriate avenues. If we are to hold the CCP to account, we must do so domestically. And the difficulty really comes into whether or not states will be prepared to exercise universal jurisdiction. And is the ability for courts to hold. Practically that would not happen. Is the UK does not have any perpetrators in its custody, and the exercise of universal jurisdiction diplomatically would be massive. So I don't think actually holding the CCP criminally accountable is possible. You know, the UN, I don't think there's appetite for it, and international courts are blocked. So regrettably, the only actions I think that can be taken in respect of Uyghurs turn on actually how states now cooperate with the CCP and whether or not they allow the CCP to continue their genocide against the Uyghurs with impunity. Does that answer the question?
Yes, thank you so much.
Thank you.
We've had one more question sent in. So it's given the repeated failure of the UN in stopping or intervening in genocides, is it time for the international community to consider a more direct approach where diplomacy fails? Could this be in the manifestation of military intervention in cases where genocide can be proven? And considering where military intervention has strongly failed before, what other stronger actions could be taken?
Okay, so there's a lot in there and I'll try to unpack it. So in respect of the UN, I think I've already briefly touched on sort of China's role at the UN and the inability of international courts. And that, I think that comes to the heart of the question. If we are to discuss military intervention to prevent genocide when it's proven, well, who would prove it? You know, that there aren't any courts available for that determination to be made. And that is really the stumbling block. And I think you'd struggle as well with the use of military force because of, again, China's position on the UN Security Council. I think when it comes to establishing either different routes internationally, you would struggle. And the reason being is that when it comes to international law, it's a bit different to the way we view domestic law. International law is fundamentally governed by consent. And the reason being is there is no enforcement arm of either court. You know, so if the ICC makes a judgment or the ICJ passes a judgment, it does not have an enforcement body to enforce that judgment. International courts and law must be based on consent, so any judgment is upheld. It's why the ICJ can only hear contentious cases where those parties agree to the consent to the jurisdiction of the ICJ. If they didn't, you know, the ICJ could pass its judgment and the other party would simply ignore it. You know, it would say, I didn't consent to the jurisdiction, I don't accept the jurisdiction of this court, and I won't accept its ruling. And that would fundamentally undermine any efforts to apply international law. I think diplomatically is where the difficulty is. You know, at the UN, there has been significant support for China in its perpetration against the Uyghurs. There has been some countries, of which the UK has been a part, who have condemned the CCP. But until we start to see the balance shift diplomatically and internationally, I don't believe any change at the moment will come. Really, what must change is political will. And until that happens, it annoys me to say it, but I don't think much will change in the short term.
Thanks, Joe. Another question that we've had sent in is, are there any examples where you think a country has taken good action to prevent crimes against humanity leading to genocide?
I think it's difficult. I think, and this is the one key thing I will add, because and I'll bring it back to the Uyghurs again, because it's a slightly different circumstance. When we look at genocides that have been perpetrated, or crimes against humanity that have been perpetrated recently, they have ordinarily been a part of some form of military or armed conflict. You know, when you look at Bosnia, Rwanda and so forth, it was part of a military armed conflict which would justify states intervening militarily. And often when it comes to sending in a UN force or a mission that is designed to prevent the further perpetration of these international crimes, it's done so on the basis that militarily we're already at that stage where forces are needed. It becomes much more difficult in times of peace. And this is the one thing I would add in particular about the Uyghurs. You know, China is not in a military conflict. It's committing this genocide in a time of peace. States at the moment, I think, would genuinely struggle to justify any form of military intervention in those circumstances. But I think states are also exceptionally naive as to how far they think their diplomatic efforts would go. You know, raising your concerns with the CCP will do nothing. States really must look at how they respond and collaborate with a criminal state. You know, at the moment, the UN, as already been mentioned, and international courts are either fundamentally flawed or barred from implementing the justice we expect. So I really think political will and ambition to get this on the agenda, working collaboratively and internationally, and responding quite, I wouldn't say aggressively, but robustly to criminal states, I think is certainly at the moment, considering the flaws, the most effective action we can take.
Great, thank you. And one more question got sent in. During the trade bill amendment campaign, Dominic Raab seemed, during the debate, really, prior to the debate, I think it was the week before, he seemed really confident that although, you know, we can't really justify any intervention or having, you know, the UN go to China and try and investigate what's going on, you know, he seemed really confident that we could get an independent body into China and to carry out this investigation for us. And he was hit back with a lot of comments saying, we don't think that's feasible. But he kept saying, we have to try our best. We have to try our best. The question is, do you think it's feasible? Do you think that there is enough international pressure, or there could be enough international pressure to get an independent body in to carry out these investigations if it can't go via the UN?
Okay. At the moment, no, I don't think there is enough international pressure to get an independent body in. I think what's key is China has, frankly, refused any form of UN investigation into their crimes. And what will concern me is that even if it was an independent or third-party investigation, it would have to ensure that it was thorough. You know, it would be, I think, more damaging to have an investigation that allowed the CCP to cover up their atrocities or frame them in another way than having no investigation at all, because frankly the CCP would use that to justify saying, look, we're not committing genocide, or look, there aren't human rights abuses here, when in fact there are. I think what is particularly powerful is people's tribunals. You know, we saw it with the China Tribunal in 2019, which looked, among other things, at forced organ harvesting. There's recently been established in the UK the Uyghur Tribunal, chaired again by Sir Geoffrey Nice QC. And the reason I think they are exceptionally important is because they compile, quite, I think, compelling and authoritative judgments on these issues. And if you have judgments such as those, you know, you will start to see the political will, the pressure building for a UN investigation. At the moment, as I said, there isn't that pressure at the UN. China has, I believe, far too many allies on this issue, or at least states not prepared to stand up to these abuses. And until we start to see a change, which I would hope the UK would want to lead, the UN and any other form of pressure and investigation simply, I don't believe, will materialise.
Thank you so much. If any of you guys have any more questions, please do let us know. Otherwise, I think we'll wrap up. Joe, is there anything else you want to add in particular?
That's everything from me. If there are any questions, you know, I always keep my DMs open on Twitter, so please do drop me a message, and I'm happy to answer any questions you may have.
Fab. So thank you so much. Thank you, Joe. It's honestly an honour working with you. Kirsty and I learned so much from everything Joe discusses with this, and we know how informative this has been. You can check out our socials at Yet Again UK, and you can also go on our website www.yetagainuk.com, follow our work and keep up to date. And like Joe said, any other questions, just give us a message and we'll be happy to answer them. Thanks, guys.
Well, thank you.